Hmm. Please, Your Lordship.
Yes.
Lordship, I beg to mention item 49, Your Lordship.
49.
49, Your Lordship.
Yes.
If it can be passed over for today, Your Lordship.
Mr.
Sushil Check.
Rositan. Okay. Item 49. Mr. Tosi Tangent Pongenus, learning counsel for the petitioner is present. On the prayer of MSS Mary, Learned State Council, the case is possible for the debate.
Not that, Your Lordship.
Yes,
Mr. Lordship. Lordship, yeah. The petitioner also admitted that there is no break of service. So when there is no break of service, his contract service has to be counted. So there is nothing wrong with the release order, Your Lordship. Then, Lordship, my learned senior counsel, he has stated that how can the office memorandum overrule the statutory provision, Your Lordship? The office memorandum was passed in compliance with the direction of this honorable court, the judgment of this honorable court. So, Your Lordship, when he does not question the validity of the judgment passed by this honorable court as well as the OM, he cannot challenge, he cannot submit in that line, Your Lordship. Then on the other question, Your Lordship, the learned, my learned senior counsel also has the apprehension that under the CCS pension rules, his contract service does not count towards the pension. That is wrong, Your Lordship. Under the rule, the CCS rule, that is Rule 13, it clearly says that when a temporary, Lordship, when a temporary service is followed by regularization, Your Lordship, the period served under the contract appointed is counted towards pension, Your Lordship.
temporary capacity would include.
Include a contract ad hoc appointment also, Your Lordship.
Hmm.
So when it is followed by regular appointment, the period served under the contractual or temporary is counted towards pension, Your Lordship. So even here also we have counted her service for the purpose of retirement. That also will include for the purpose of pension, Your Lordship. So she is holding a pensionable post. Because a petitioner admitted that there is no break of service. Yes. Then, Your Lordship, my learned single council also, he has referred to the state civil list, where in his date of entry into service was mentioned as 4/12/1991. But the civil list, Lordship, I may take you to page 67 of the writ petition. The preface of the civil list is very clear. 67 page. Para 3, Your Lordship. The contents of the state civil list do not confer any official sanction in respect of the particulars depicted therein, including the date of birth and relative seniority of individual officer. In case of any doubt or dispute, the correct information would be required to be ascertained from the original records available with the department concerned. So, Your Lordship, this civil list does not give confer a right to the petitioner. So, Your Lordship, it's very simple that when the petitioner admitted that there is no break of service, and she admitted that she joined as drug inspector on contract basis on 4/9/1989. Thereafter, her service was regularized through MPSC, Your Lordship. So for the purpose of the act, we have counted her retirement, Your Lordship, for 37 years counted from 4/9/1989, and she is to retire from service on 30 of this month. So, Your Lordship, no interference is called for. That's all, Your Lordship.
Yes, I think.
My senior had rushed down to Agadala Lodge. He has a fixed matter on the 25th. The lodge may kindly accommodate on the Friday lodge.
There is what? There is nothing.
Actually, the content of the batch of read appeals, para 3 and para 5 of the office memorandum lodge.
Full bench decision is quite clear. There is,
Yes, Lordship, this
at
integrate,
least single bench cannot
Yes.
do anything.
yes,
I am making the road clear to you.
yes, Lordship. Even in integrant law case, your Lordship, after this honorable court has dismissed her review petition, she has appealed to the Supreme Court. Supreme Court has upheld the decision, so your Lordship, there is nothing.
That Supreme Court. Oh, yes, initially writ appeal was preferred by
Yes.
Imti Renla Jamil.
Yes, Lordship.
Then
yes.
again, review petition was
Yes,
preferred.
yes, yes.
That was a case of
7 days,
alleged break in service.
yes, yes, but here there is no break of service, so your
Even if
Lordship,
that claim
Yes.
was rejected by the
Yes.
Supreme Court.
yes.
And it is your case, clear case.
Mm.
There is nothing to,
Lordship, I leave with the wisdom of this honorable lodge.
there she claimed, I think, resignation,
Yes.
something like that.
Yes, Lordship, it was
resignation.
pertaining to resignation.
Pretending to
Yes,
be
Lordship.
resignation. Clause 6 was referred to there also.
Yes, Lordship.
I think. Is there any, who is the office memorandum?
Page 35, Lordship.
Was there any other office memorandum dated 29/3/2017?
Your Lordship, it was mentioned in the writ petition.
Writ petition?
Yes.
Which paragraph?
Wait, hold on, there.
Perimetry exact.
Yes,
Almost.
exactly, Lordship.
Hmm?
Yes. Because this OM data 29.
No, there will. Paragraph 15. Supreme Court in that case upheld that rule 26(2), which we have hold that if the resignation followed by found no force in the submission of the petitioner. Yes, any other matter, Mr.? Any other? Any other hearing?
Right after this, we have one more. Yes.
We are dictating it. Please take a seat. Where is that 14/6/2024 order? Which you have impugned?
Page 100.
Page 100.
Subsequently, there was another original motion. Page 103.
103.
It has conveyed the decision of the government.
Zero three. That is prayer B.
Close.
And what is prayer C? That means 9/7/2024.
Yes, Lord. Page
Which-
103. Lord.
That is page 103.
103.
Then what is B?
Being the page 100 logic.
Page-
Order dated 14/6/2024.
No, B is 31/5/2024. What is that? B.
This is the government's decision. PNR logic. Also find page 99.
99.
Logic. Where E would be located, page 100. logic.
The writ petitioner invoking the extraordinary jurisdiction under Article 226 of the Constitution of India has assailed, has entirely assailed an order dated 14/6/2024, Annex of 25, passed by the Government of Nagaland in the Health and Family Welfare Department. And a corrigendum issued in connection with the order, the corrigendum dated 9/7/2024, Annex of 26, issued in connection with the order dated 14/6/2024 Supra, issued by the Government of Nagaland in the Health and Family Welfare Department. Also, the petitioner has also assailed an impugned approval of the Personnel and Administrative Reforms Department, OM branch wide U full stop O full stop number 219 dated 31/5/2024. Full stop. By the aforementioned order stroke corrigendum impugned herein, the petitioner has been informed in a sense, that lady, right, she'll be released from service on 30/09/2024. As per the provision contained in section 3 within bracket 1 of the Nagaland Retirement from Public Employment Act, 1991, as amended. Full stop. Terming such decision of the state government as an order of premature retirement from service, the petitioner has preferred the writ petition with a claim that the service of the petitioner is to be counted only with effect from 4/12/2019. Full stop. Para. The primary ground of challenge is that a period of $35 of public employment would not be completed on (30/09/2024). The date when with the petition has been sought to be released from service. Full stop. Para. The relevant facts the pertinent facts which led the petitioner to institute the writ petition can be exposited, in brief, as under. Para. Mr. Jamil, you can take your seat. If you want to clarify something, then you rise. It was in the year 1989. The petitioner came to be appointed in a post of drug inspector within bracket class dash Roman 1, gazetted bracket close. Page 38. With a scale of pay plus other applicable allowances by the Secretary to the Government of Nagaland, Health and Family Welfare Department. by the notification dated 4/9/1989. Full stop. By the notification dated 4/9/1989, comma, Indian notification. It was mentioned that the appointment of the petitioner to the post of drug inspector was purely on contract basis for a period of 1 year, subject to termination by giving 1 month notice in writing from either side. Full stop. The petitioner was appointed as a drug inspector on contract basis initially under the civil sergeant, comma, Ukha, against an existing vacancy. Full stop. In terms of the notification, comma, a contract agreement was also executed laying down the terms and conditions of the contractual engagement. Full stop. By another notification dated 22/02/1991, comma, the contract service of the petitioner in the post of drugs inspector under the Nagaland Health Services came to be extended for a period of further 1 year from 5/9/1990 to 4/9/1991. And accordingly, comma, another contract agreement was executed between the parties. Full stop. By a notification dated 16/9/1991, the Government of Nagaland in the Health and Family Welfare Department extended the contract services of the petitioner in the post of drugs inspector for another period of 1 year, WEF 5/9/1991. Full stop. Para. During the interregnum, comma, a process of recruitment was initiated by the Nagaland Public Service Commission to fill up the vacancies of drugs inspector within bracket class Roman 2 gazetted under the Nagaland Health Services in a regular manner. Full stop. By full stop. The petitioner participated in the state process of recruitment initiated by the NPSC by submitting her candidature. Full stop. during the continuation of our contractual service, which initiated contractual service, which was extended from 5/9/1991, comma, the results of the recruitment process initiated by the NPSC were declared post hoc as the petitioner emerged as a successful candidate, comma, as the petitioner was recommended by the NPSC for appointment, comma, she came to be appointed in the post of drugs inspector under the Nagaland Health Services by the state government, by the government of Nagaland, the Health and Family Welfare Department, by a notification dated 19/6/1992. Along with two others. Full stop. On a regular basis. Full stop. In the notification, comma, dated 19/6/1992, comma, it was mentioned that the appointment of the petitioner would be on probation for a period of 2 years, subject to termination of service by giving 1 month's notice in writing from the either side. Full stop. On receipt of the order of appointment on regular basis, comma, the petitioner joined service in the regular post of drugs inspector and in course of time, comma, the petitioner came to be regularized or confirmed? Regularized on completion of the probationary period of 2 years. By a notification dated 4/5/1995. Right? Para. The services of the petitioner was also confirmed by notification dated 13/9/2021 of the Government of Nagaland in the Health and Family Welfare Department. And in the same notification, comma, the effective date was mentioned as 4/12/1991. On 1/4/2015, Commander Chief Secretary to the Government of Nagaland brought out the sixth edition of the state civil list within bracket as on 1st January 2015 bracket close in respect of the services in the state. And in the state civil list, comma, the details of the employees serving in various departments under the state government, including the Health and Family Welfare Department, comma, were mentioned, including the Health and Family Welfare Department within bracket drugs control. Full stop. As per the said state civil list, comma, a petitioner who was then serving as an assistant drugs controller with a B Farm degree, comma, was shown to have entered into government service on 4/12/1991. It is pertinent to mention herein that in a notification dated 19/6/1992, whereby the petitioner came to be appointed as a drug inspector on regular basis, comma, it was mentioned that the appointment was with effect from 4/12/1991. As what is page 88, Mr. Zamir? What is page 88?
88 Lord. Representation.
Why?
This is against the 2020 state civil list law.
2020.
Where the name was shown as 1989 law.
When in the state civil list published in the year 2020,
Lord,
the petitioner's entry into government service was shown as 4/9/1989.
Lord,
A petitioner submitted a representation before the Principal Secretary, Health and Principal Secretary to Government of Nagaland, comma, Health and Family Welfare Department. On 11/7/2022, to rectification of such date of entry into government service from 4/9/1989 to 4/12/1991. Full stop. On submission of the representation, comma, communications were exchanged between various authorities as regards the matter of date of entry or the petitioner into government service. Full stop. Where is that notification regarding that page 94? This data code, something like that. Some notification you indicated.
This was with regard to.
As per the data published, as per the data, data published in terms of the Personnel Information Management System, PIMS, comma, the petitioner's date of joining was shown as 19/6/1992. Full stop. It is in the backdrop of the aforementioned events, comma, the Personnel and Administrative Reforms Department in U full stop O full stop number 219 dated 31/5/2024 had observed that after examination of the matter in terms of para 6 of the office memorandum dated 31/8/2017, comma, it was revealed that no, it was revealed, no? It was observed that the petitioner shall be treated to be in public employment from the date of her initial appointment on 4/9/1989 and after calculation it has been found that the said date, comma, that is, comma, 4/9/1989 was to be taken was to be considered for the purpose of retirement under the Nagaland Retirement from Public Employment Act 1991, comma, as amended, full stop. Pursuant to the said U full stop O full stop number 219 dated 31/5/2024, comma, the impugned order dated 14/6/2024 came to be issued under the hand of the came to be issued by the Health and Family Welfare Department, Government of Nagaland. Observing that the petitioner was to be released from duty on retirement on completion of 35 years of service stroke on attaining of age 60 years in terms of section 3 within bracket 1 and section 3 within bracket 2 of the Nagaland Retirement from Public Employment Act, comma, as amended 1991, comma, as amended And a notification dated 7/8/2009 of the Personnel and Administrative Reforms Department on 30/09/2024. Full stop. In the impugned order dated 14/6/2024, it was mentioned that the petitioner was then serving as the Deputy Drugs Controller, DH, Roman, Department of Health and Family Welfare. And her date of entry into government service was shown as 5/9/1989. Full stop. What is the correction then, corrigendum?
The government's approval was incorporated.
Okay. The corrigendum dated 9/7/2024 was issued to incorporate the approval of the Personnel and Administrative Welfare Administrative Reforms Department's U full stop O full stop number 219 dated 31/5/2024. That much. Full stop. Para. I have heard Mr. S.S. Day, Lawyer Senior Counsel, assisted by Mr. Moa Jamir, Learned Counsel for the petitioner, and M.S. V. Sukri, Learned Additional Advocate General, for all the respondents. Also, Para, Mr. D, Learned Senior Counsel appearing for the petitioner, has contended that the release, the impending release of the petitioner from service on and from 30/09/2024 would be in violation of the provisions of the Nagaland Retirement from Public Employment Act 1991, more particularly, Section 2(1) and Section 3(1) thereof. Full stop. He has pointed, he has referred to an office memorandum dated 31/8/2017. 2017 of the P and AR, Personnel and Administrative Reforms to P and AR Development Department. To contend that the said notification, which can at best be a subordinate no, can which can avoid কি করলো? It contains a decision of the state government to the effect that the period of service rendered on ad hoc stroke contract stroke work charge stroke substitute basis which is followed by regularization or regular appointment shall be treated as public employment under the short form Nagaland Retirement from Public Employment Act 1991 as amended. Full stop. According to him, the said decision contained when the said decision contained in para 6 of the office memorandum dated 31/8/2017 is considered in juxtaposition with the statutory provision contained in section 2(1) and section 3(1) of the Nagaland Act, then it would clearly emerge that the decision of the government had, in essence, supplanted the statutory provisions contained in section 2(1) and section 3(1) of the Nagaland Act. And what is the other one point contended? Other point?
Pensionable post.
Mr. Dey has further submitted that when the petitioner extended her service prior to her regular appointment on contract basis, it was not pensionable service. And as such, the state government could not have taken such period of contractual service within the period of 35 years as the same would be contrary to the Central Civil Services within bracket pension rules 1972. Full stop. He has further contended that the state respondents were obligated to proceed with the service records mentioned in the state civil list 2015, wherein the date of petitioner's entry into government service was shown as 4/12/1991. It was improper on the part of the state respondents to interfere with such settled position of law. With such contentions to come on the petition of the Mr. Day, Senior Counsel, has contended that the period of public employment of 35 years is to be counted only from the petitioner's date of joining into the post of drugs inspector on regular basis pursuant to the recommendation of the NPSC and the order of appointment issued by the state government. And has sought setting aside and quashing of the impugned orders as being illegal, as being bad and illegal. Para or contrary, MS Sukri learned additional advocate general appearing for the state respondents has submitted that it has been settled that the term public employment would include ad hoc stroke contractual service discharged by an employee prior to his stroke her regularization or regular appointment for the purpose of counting public employment of 35 years if such regularization or regular appointment is without any break in service. It has been contended that at the time of publication of the state civil list 2015, it was made clear that the details incorporated therein, in case of dispute or doubt, would be ascertained from the original service records available with the department. And as such, it is not correct on the part of the petitioner to contend that the details incorporated in the state civil list 2015 were only to be adhered to. Full stop. Yes, what is the other one?
Is that the office memorandum that was issued in compliance with the judgment of the.
It has been submitted that the office memorandum dated 31/8/2017 was issued by the government of Nagaland in the P and AR departments only in pursuance of the observations made by this court, by the division bench of this court in its various orders, WADA definition of public employment defined in section 2(1) of the Nagaland Act. And it does not. And it cannot be contended that paragraph 6 of the State Office Memorandum was in violation of any of the provisions of the Nagaland Act 1991 as amended. Learned counsel for the parties, the learned counsel for the parties have referred to a full bench decision of this court in Asangla TIR versus Tungdeno Mojui and others, reported in 2021. 3 ZLR 238, to buttress their respective submissions. I have duly considered the submissions of the learned counsel for the parties. And I've also gone through the materials on the record, as well as the decision of the full bench of this court in Asangla TIR Supra. The facts as narrated above are not in dispute. The petitioner initially joined service under the state government as a drug inspector pursuant to the notification dated 4/9/1989 on contract basis for a period of 1 year initially. The contractual service of the petitioner was extended on 2 subsequent occasions. While notification dated 22/02/1991 and 16/9/1991 posted. By the notification dated 22/02/1991 and the notification dated 16/9/1991, the petitioner's contractual service was extended up to 4/9/1991 and up to 4/9/1992. It was during the period when the petitioner was extending her contractual service pursuant to the notification dated 16/9/1991, the petitioner came to be appointed in the post of drug inspector in the Nagaland Health Service by the government of Nagaland in the Health and Family Welfare Department by the notification dated 19/6/1992 on being recommended by the NPSC. It is not the case of the petitioner that there was any break in service between her contractual service and her regular service. No dispute. Where the petitioner has raised with contention on the basis of paragraph 6 of the office memorandum dated 31/8/2017. Postal. For ready reference, paragraph 6 of the office memorandum dated 31/8/2017 is quoted herein below, page 36, paragraph 36. Nagaland produce software. But at this juncture, it would be apt. It would be beneficial to refer to the provisions of the Nagaland Act. Postal. The Nagaland Retirement from Public Employment Act. Here, para 22 report for you. 2022 1 GLR 630 para 22 put for you. Section 2(1), section 3(1), and section 5. A to A. A to A. Subsequently, a few provisions of the Nagaland Act 1991 came to be amended by the Nagaland Retirement from Public Employment Act. Public Employment within bracket Amendment Act 2007. Here at 22.12 B2B. The para next C2C. Which one? This one. Miss Preet, there, paragraph 6.
Yes, yes.
It is pertinent to mention that in an earlier office memorandum dated 29/3/2017. There was a perimeter. No, sorry, in an earlier note, so and so, office memorandum dated so and so. Paragraph 6 therein was almost perimeter to paragraph 6 of the office memorandum dated
This is 2017.
31/8/2017. Office memorandum issued by the P and RD Department, Government of Nagaland. Clause 6 of the said office memorandum dated 29/3/2017 was as under. Wait. And which notification the full bench has referred?
Motion.
Do you have the full bench judgments?
I don't have the full bench judgment.
Paragraph 16. There is mention of another notification, 4/5/2017. How many notifications you are? See paragraph 16. The same might be perimeter. Quoted. Then office memorandum quoted.
4/5/17.
So many office.
So many. Which one?
But your lordship, if you pick office memorandum annexed in the writ petition,
Ah.
it stated that the earlier office memorandum has been superseded by motion.
Okay.
Yes.
By paragraph 6/7. In paragraph 7 of the office memorandum dated 31/8/2017, it has mentioned that the office memorandum dated 31/8/2017 has superseded all office memoranda on the subject, including the office memoranda dated 29/3/2017. Full stop. Subsection 1 of section 3 of the Nagaland Act, as it exists on date, contains a non-obstante clause post of the statutory prescription contained therein. This is the final one, ultimately amended one.
Yes, Lord, 2009.
Has prescribed that a person in public employment can either hold office for a term of 35 years from the date of joining public employment, or till he or she attains the age of 60 years, comma, whichever is earlier. Those two. Para. As has been provided in paragraph, section 2 has been amended. Later on, no, it has remained as the original. Okay. It has been provided in section 2 that public, quote unquote, public appointment means appointment to any pensionable so and so, so and so. Paragraph 2. Para. Before the full bench in Asungla TII, no, the matter, the reference made to the full bench of this court in Asungla TIR Supra was to the following effect. Para 2 আছে না? Para 2 এটা ব্র্যাকেট দিয়ে আছে। Whether the definition of quote unquote public employment, comma, referred above would necessarily mean that a person has worked on a post which was pensionable or will include contractual stroke ad hoc service as well, comma, which are not pensionable. Para the full bench, while deciding the issue, comma, has referred to a number of earlier decisions, including the decision rendered by the Honorable Supreme Court in Nagaland's Senior Government Employees Welfare Association and others versus State of Nagaland and others, comma, 2010 7 SCC 647. And has referred to, has quoted paragraph 36, comma 50, paragraph 50 and paragraph 61 from Asangla TI. Thereafter, comma, the full bench proceeded to answer the question as to whether the contractual employment as well as ad hoc employment would be included in the period of 35 years of public employment by the government. In answering the question, comma, the fulminants has observed as under paragraph 8. Paragraph 13. Paragraph 14. Paragraph 16. Paragraph 17 or underlying portion. No, 17 to be. Paragraph 18 also. Or paragraph 19. Hmm? Well, reverting back to the facts of the case in hand, comma. It is clear that for the purpose of calculating 35 years of public employment, in case of a petition, the services rendered initially under contract on and from or 1989 is to be included as during the continuance of such contractual service, comma, the petitioner came to be appointed. In regular post pursuant to her appointment by the state government after being recommended by the NPSC on 1992 as the transition from the contractual service to regular service was without any kind of break whatsoever. Full stop. In such period of matter, comma, the period of petitioners 35 years of public employment is to be counted on and from 4/9/1989. And on that basis, comma, the period of 35 years of public employment would be completed in September 2024. Close the para. The contention raised on behalf of the petitioner that the details entered in the state civil list 2015 and the details incorporated in the Personal Information Management System PIMS are only to be considered, comma, upon consideration is found not acceptable for the reason that the for the reason that if the service details of the petitioner based on which the impugned orders have been passed are on the basis of records, service records available with the state respondents. Then it is the service records which should receive precedence. Full stop. In any view of the matter, comma, in the at the time of publication of the state civil list, it was clearly mentioned that the contents of the state civil list would not confer any official sanction in respect of the particulars depicted therein of the individual officers, and in case of any doubt or dispute, the correct information would be ascertained from the original records available with the department concerned. Full stop. Para. Insofar as the contention raised by the learned senior counsel for the petitioner with regard to incongruent nature of the office memorandum dated 31/8/2017 is concerned, comma, the same uh, it is found that the fullments in Asumla Tia Supra has considered the said aspect in details. Full stop. Moreover, comma, on perusal of the entire contents of the office memorandum dated 31/8/2017, comma, it has emerged that the office memo, the said office memorandum was issued pursuant to judgments, pursuant to a judgment and order dated 24/7/2012, rendered in PS 35, rendered in WA number so and so, underline PS 35. And a judgment and order dated 14/3/2017, passed in writ appeal number 5K of 2017. Querying. It has been categorically held that the period of service rendered on ad hoc stroke contract stroke work charge basis has to be counted for computation of public employment under the Nagaland Retirement from Public Retirement, Nagaland Retirement from Public Employment Act, comma, 1991, comma, as amended by the Nagaland Retirement from Public Employment Second Amendment, bracket or before, Act 2009. Full stop. Having considered the authoritative pronouncement of the full bench in Asungla EIR, comma, holding that 35 years of service is to be calculated. No, holding that in determining the date of superannuation of an employee under the Government of Nagaland, in terms of section 3 within bracket 1, it's in terms of section 2(1) and section 3(1) of the Nagaland Act. For the purpose of counting 35 years, his stroke her period of employment, be it contractual or ad hoc, shall be calculated. And the said period will also be calculated for giving pensionary benefit to the employee when such service is followed by regularization. We do not find any force in the contention. First of. Furthermore, Rule 13 of the CCS pension rules has provided for counting temporary service to calculate to determine the date of commencement of qualifying service. If such temporary service is followed without interruption by substantive appointment in the same or another service or post. In view of the discussion made above and for the reasons assigned therein, we this petition is found to be bereft of any merit. To interfere with the for interfering with the orders impugned herein, impugned, whereby the petitioner has been sought to be released from public employment on completion of 35 years of service on 39/2024. Full stop. Consequently, the petition stands dismissed.
Lordship, the name of Inaholi water may be recorded in.
Supri, assisted by
Inaholi water.
Inaholi.
Water.
Acha.
Much better.
And there shall be no order as to costs.
For hearing, item number 40.
Yes, what is the matter, Mr.?
Seniority disputes within the police ranger of the same degree.
Hmm. You can take up on some other dates. This week,
Tomorrow,
say Wednesday.
when you see that
Huh?
the division based day.
Thursday then, Thursday. Okay. Thursday will take up. Parties are ready. Okay.
It's a middle game. This is our first item on this.
Huh?
Our first item.
No, we'll not show up. When I see you, I'll take up. Item number?
40.
40.
Okay, Lima Wapang Learned Counsel for the petitioner, V. Supri Learned Additional Advocate General for the state respondents, and Mr.
Respondent number 4, 5, and 6, Mr. Gachishik.
Your name
Mr. Gachishik.
for the respondent number so and so. As sought for by so and so, release the case on Thursday.
The first item.
Thursday. I'll be here, you'll be here. I got backache by sitting in that chair still. Today morning, I had difficult like